from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or what witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different, it could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records, which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
For a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up. And the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interviewed the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it. For this reason, intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked, and whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and in what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way to
treated other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand. Because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Yes, you may.
I hope someday when this political craziness is over, you will look back again on this, because this is the FBI you know and love. This was done by pros in the right way. That's the part I have no patience for. Sorry, sir.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director.
Minutes of questioning for doing so, so thank you very much. Director, thank you for your accessibility. You have been very readily available, and we do appreciate that. This investigation started because the Inspector General found classified information in a non-secure setting, and the FBI went to a law firm and found this information. They seized at least one computer and at least one thumb drive. Did you need an immunity agreement to get those?
It was not. I don't think there was immunity. In fact, I'm certain there was no immunity agreement used in connection with that.
So did it really take the FBI a full year to figure out that Cheryl Mills and Heather Samuelson also had computers with classified information on?
No. It took us to that point in the investigation to insist that we try to get them.
Were you getting them because they had classified information or because there was some other information you wanted?
No, we thought those were the tools, as we understood it, that have been used to sort the emails. And the investigative team very much wanted to understand, if they could, whether there was an electronic hail of how that had been done. Because the big issue was, what did they delete, what did they keep?
But why did you need an immunity agreement? Why didn't they just cooperate and hand them over? The law firm did, didn't they?
Well, yes. That's a question really I can't answer. That's between a lawyer and her client and the Justice Department lawyers. For whatever reason, her lawyer thought it was in her interest to get an active production immunity agreement with the Department of Justice.
The FBI interviewed David Kendall's partner, but did not interview David Kendall. Why didn't you interview David Kendall?
I don't remember. I don't remember that decision.
Going back to this Reddit post, this is put up on July 24th of 2014. You believe this to be associated with Mr. Gambetta, correct?
Yes, I think that's right.
This is the one that Mr. Jordan put up about the need to strip out a VIP's very VIP email address and a bunch of archived email. This is he's referring to a federal record, isn't he?
I don't know exactly which records he's referring to.
How is this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
Sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, depending on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit on these records.
Sure. That's why the guy wouldn't talk to us without immunity.
And so when you got immunity, what did you learn?
We learned that no one had directed him to do that he had done it.
You really think that he just did this by himself?
I think his account, again, I never affirmatively believe anybody except my wife, but the question is, do I have evidence to disbelieve him? And I don't. His account is credible that he was told to do it in 2014, screwed up and didn't do it, panicked when he realized he hadn't, and then raced back in and did it after Congress asked for the records and the New York Times wrote about them. That was his SHIT moment. And that was credible. Again, I don't believe people, but we did not have evidence to disbelieve that and establish someone told him to do that. No email, no phone call, nothing. The hope was, if he'd been told to do that, that'd be a great piece of evidence. If we give him immunity, maybe he'll tell us, so-and-so told me to, so-and-so asked me to, and then we're working up the chain.
But he did indeed destroy federal records, and he was told at some point to do this, correct? Who told him to do that initially? When he was supposed to do it in December, and he didn't do it. Who told him to do that?
One of Secretary Clinton's staff members, I can't remember sitting here, we know that. One of her lawyers might have been Cheryl Mills. Someone on the team said, we don't need those emails anymore, get rid of the archive file.
This is what's unbelievable about this, because there's classified information, there are federal records that were indeed destroyed. And that's just the fact pattern. Let's go back to this. Here's the other thing that I draw to your attention that is new. September 15th of this year, I issued a subpoena from the Oversight and Government Reform Committee. On these Reddit posts, 4 days later, they were destroyed or taken down. They were deleted. I would hope the FBI would take that into consideration. Again, we're trying under a properly issued subpoena to get to this information. Let's go to Heather Mills real quick. How does in the 2016 interview with Cheryl Mills, she says, quote, Mills did not learn, in the interview report, the interview summary from the FBI, Mills did not learn Clinton was using a private email server until after Clinton's tenure. Back, also, you have this interview with Mr. Pagliano, who said he approached, quote, Pagliano then approached Cheryl Mills in her office and relayed a State Department employee's concerns regarding federal records retention and the use of a private server. Pagliano remembers Mills replying that former secretaries of state had done similar things, to include Colin Powell. It goes then on to a page 10, and this is what I don't understand. The FBI writes, Clinton's immediate aides, to include Mills, Abedin, Sullivan, and a redacted name, told the FBI they were unaware of the existence of a private server until after Clinton's tenure at state, or when it became public knowledge. But if you look back at the email from Heather Mills, if you go back to 2010, this is to Justin Cooper, okay? Mills to Cooper, who does not, he works for Clinton's. He doesn't work for the State Department. FYI, HRC email coming back. Is server okay? Cooper writes back, you are funny. We're on the same server. She knew there was a server. When there was a problem with Hillary Rodham Clinton's emails, what did they do? She called the person who has no background in this, who's not a State Department employee, no security clearance, and then tells the FBI, well, I never knew about that. But there's direct evidence that contradicts this. How do you come to that conclusion and write that in the summary statement that she had no knowledge of this?
That's a question.
The
Yes.
time of the gentleman has expired, but the director will answer the question.
I don't remember exactly sitting here, having done many investigations myself.